Hello friends, welcome to a new episode of Drishti IAS Editorial Analysis. In this editorial analysis, we do three things. First of all, we link the editorial to the UPSC syllabus. Secondly, we try to understand the key points of the editorial. And thirdly, if any key concepts have come in the editorial and are important from exam point of view, we also discuss that. So let us begin today's editorial analysis.
Dear viewer, this video is available in Hindi as well. If you wish to watch it, please visit our Hindi YouTube channel, Drishti IAS. For your convenience, the link for this video in Hindi has been provided in the description below.
We have taken today's editorial from the Hindu, and the title of the editorial is Lessons for India. It says the Italian Marines case meets with a disappointing end as India loses right to trial. So let us look at its linkage with the syllabus. We find that it links directly with GS paper 2, where we have international relations as the major topic. And under this, it links with bilateral relations between India and Italy. Also, it links with important international institutions like UN clause and the Permanent Court of Arbitration, which has ruled on the matter. So after establishing the linkage with the syllabus, now let us look at its key points. Before moving on to the key points of the editorial, let us understand what the issue is all about. So the ship at the center of the controversy is Enrica Lexi, which was a commercial Italian oil tanker. And the incident pertains to 15th of Feb 2012, when two Italian marines shot dead two Indian fishermen, thinking them to be pirates. And since then the case has dragged on, and now the Permanent Court of Arbitration at The Hague has given its final ruling. So let us understand the key points of the case. So the two Italian marines at the center of the controversy are Massimiliano Lattori and Salvatore Gironi, whereas the two Indian fishermen who were shot dead by the Italian marines were Ajish Bink and Valentine Celestine, both belonging to Kerala, and their fishing boat was named Saint Anthony. And these two Italian marines were part of a security team on the Italian commercial oil tanker known as Enrica Lexi. And the incident happened on 15th of February 2012 in India's contiguous zone, 20.5 nautical miles off Kerala coast. Now here we should know that 1 nautical mile is equal to 1.85 kilometers. And the distances as well as speed on sea are measured in nautical miles. Now the tribunal, which is the Permanent Court of Arbitration at The Hague, it has given its verdict, which is a split 3-2 verdict. And the tribunal established by ITLAWS, which is International Tribunal on the Law of the Sea, under the provisions of the UN clause, which is United Nations Convention on Law of the Sea. Now this tribunal has held that the Marines are entitled to immunity in relation to the acts that they committed during the 15 February 2012 incident. So the Italian Marines have been granted immunity, which makes it clear that they will not be facing any criminal proceedings under the Indian laws, which India wanted. So India is precluded from exercising its jurisdiction over the Marines. India had earlier opposed Italy's request for an arbitral tribunal, but the International Tribunal on the Law of the Seas had ruled in Italy's favor then also. Now International Tribunal on Law of the Seas has asked both the countries to suspend all court proceedings, and accordingly the judicial proceedings against the Italian Marines in India have been suspended. Also in May 2016, Supreme Court had allowed Gironi, one of the Italian Marine who was on bail in India, to return to Italy pending the decision of the tribunal. And the other Marine, Lattori, was already in Italy because of medical reasons. So both the Marines are anyways in Italy. Now as per this latest ruling, Italy will now continue with the case it had registered against the two Marines. So the two Marines will still face the case, but it will be tried in a court in Italy. But the government of India must ensure that Italy is made to pay fully for the loss of life and suffering caused, as well as the government of India will have this duty to ensure that the trial in Italy's court proceeds in the right manner and the guilty are punished. Also, some introspection is needed to be done by the Indian executive and judiciary that how this case turned out in this manner. And here two important questions are raised. Was it prudent to appoint the National Investigation Agency to handle the case after the Supreme Court of India had ordered for a special court to be set up to try the Italian Marines? This only weakened India's position. Also, the failure in countering the deliberate delays caused by Italy in commencement of the trial, and this delay of time, it was used by Italy to build sympathy for the Marines in European Union. So India needs to consider all these angles, the legal as well as the diplomatic angles where it faltered. Though India has now decided to comply with the tribunal's verdict. So after having this background, now let us look at the key points of the editorial. The editorial says the Italian Marines case has met with a disappointing end as India has lost the right to try the two Italian Marines in India. Editorial says that the International Arbitration Court has ruled that India does not have jurisdiction to try the Marines who were entitled to immunity as they were acting on behalf of a state. Though this is controversial and many legal experts have said that this application of immunity for the Marines is a very stretched interpretation of the international law because the Marines were acting in a commercial capacity and they were engaged through a commercial contract to guard a commercial ship. Also, the Permanent Court of Arbitration, which decided in the matter and which is situated in The Hague, which is in Netherlands, admitted that both India and Italy had concurrent jurisdiction in the matter, but it still concluded that the Marines' immunity precluded India's jurisdiction in the matter. That means because of the immunity enjoyed by the Marines in their capacity as agents of the Italian state does not allow for India to try them under its criminal law. But in India's favor, the Permanent Court of Arbitration found that the Italian vessel had violated the right and freedom of navigation of the Indian fishing vessel under United Nations Convention on Law of the Seas, and that the action which caused loss of lives, property and harm merited compensation. So this point goes in India's favor, where India's claim for compensation has been recognized by the PCA, and also the fact that the Italian vessel violated the right and freedom of navigation of the Indian fishing vessel. Also, the editorial says that the PCA rejected a key argument by Italy that India, by leading the Italian vessel into its territory and arresting the Marines, violated its obligation to cooperate with measures to suppress piracy under Article 100 of the UN clause. So this makes it very clear that the arbitration court also did not see the incident as related to piracy at all. And the editorial says that the incident had caused national outrage as the public saw these as unprovoked killings, as it was very clear that there was no attempt by the fishing vessel at any kind of piracy. Also, the fishing vessel was well within India's contiguous zone, which we will see later in the key concept section. And it was very evident that the offence committed by the Italian Marines warranted arrest and prosecution under India's domestic law. Since there was no piracy angle, a regular trial was required. But here comes the weakness of the Indian state. Rather than ensuring a quick trial, the Union government delayed its response. And also the Indian criminal justice system is known for the long drawn cases. The Supreme Court wanted a special court to be set up, but it never saw the light of the day. Also, there was failure on the diplomatic front as well, where the Marines managed to obtain orders to leave the country. Also, the Supreme Court ruled that only the centre and not Kerala government can prosecute the Marines. A bigger legal issue was caused when the National Investigation Agency was involved in the probe, and it invoked the Suppression of Unlawful Acts Against Safety of Maritime Navigation and Fixed Platforms on Continental Shelf Act 2002, as this law provided for death penalty, And this created sympathy for the Marines, not just in Italy but also in the European Union, which then threatened to impose trade sanctions on India. And finally, these charges were dropped. So, by filing these charges and later on dropping these charges, India only weakened its position in the case. Finally, the editorial says that the PCS award, which is final and has also been accepted by India, is a huge setback for the expectation that the two Marines would face a criminal trial in India, though they would be facing a criminal trial in Italy. And the editorial says that Italy has succeeded in taking the matter out of India's hands, but it should now make good on its commitment to have the Marines tried under its domestic laws for the unprovoked killing of two Indian fishermen. And at the end, the editorial says that the key takeaway for India should be the lessons in the legal and diplomatic domains that can be drawn from this failed experience. So this was all in the key points of the editorial. Now let us look at key concepts. So in key concepts, let us look at United Nations Convention on the Law of the Sea, also known as UN Clause. So this is also known as the Law of the Sea Treaty and was adopted in 1982 to establish jurisdictional limits over the ocean areas. And the convention defines a distance of 12 nautical miles from the baseline as territorial sea and a distance of 200 nautical miles distance from the baseline as exclusive economic zone limit. India became a signatory to the UN clause in 1982 itself. And we should know that UN clause has created three new institutions. One is the International Tribunal for the Law of the Sea, ITLOS, which is an independent judicial body to adjudicate disputes arising out of the convention. Second is the International Seabed Authority, also known as ISA, and it is a UN body set up to regulate the exploration and exploitation of marine non-living resources of oceans in international waters. The third body is the Commission on the Limits of the Continental Shelf, and it facilitates the implementation of the UN clause in respect of the establishment of the outer limits of the continental shelf beyond 200 nautical miles. So these three bodies are important and we should know. Now let us look at the UN clause maritime zones. So UN clause basically divides the marine areas into 5 main zones, which are internal waters, territorial sea, contiguous zone, exclusive economic zone and the high seas. Now let us look at all of these zones in some detail. So here in this diagram we can see that this is the baseline and the waters from the land to the baseline are known as internal waters, where the state exercises full sovereignty. From the baseline, 12 nautical miles comprises the territorial sea and 24 nautical miles from the baseline is the contiguous zone of the country and 200 nautical miles from the baseline is the exclusive economic zone of the country. After this contiguous zone, the high sea area starts where international law applies. This incident of Enrica Lexi happened in India's contiguous zone of the Kerala coast. So what is baseline? It is the low water line along the coast as officially recognized by the coastal state. And what is internal water? Internal waters are waters on the landward side of the baseline from which the breadth of the territorial sea is measured. And each coastal state has full sovereignty over its internal waters, like its land territory. And examples include bays, ports, inlets, rivers, and even lakes that are connected to the sea. Also, one important thing is there is no right of innocent passage through internal waters. An innocent passage refers to passing through the waters which are not prejudicial to peace and security. However, the nations have the right to suspend the same. Territorial sea. Territorial sea extends seaward up to 12 nautical miles from the baseline. And nautical mile, we know that 1 nautical mile is equal to 1.85 kilometers. And in the territorial sea, the coastal states have sovereignty and jurisdiction totally. And these rights extend not only on the surface but also on the seabed, subsoil and even airspace. But in territorial sea, the coastal states' rights are limited by the innocent passage through the territorial sea. So that is allowed in the territorial sea but not in inland waters or internal waters. Now we see the contiguous zone. It extends seaward up to 24 nautical miles from its baselines and it is an intermediary zone between the territorial sea and the high seas. And in this contiguous zone, the coastal state has the right to both prevent and punish infringement of fiscal, immigration, sanitary, and customs laws within its territory and territorial sea. So, in this contiguous zone, 4 kind of laws can be applied by the coastal state, and these 4 laws deal with customs, immigration, sanitary, and fiscal measures. So, an acronym to remember this is CISF. CISF we know is Central Industrial Security Force, but here we can remember that CISF is allowed in the contiguous zone. So, a coastal state can have 4 laws applicable in the contiguous zone which deal with customs, immigration, sanitary, and fiscal laws. Also, another important thing is that the contiguous zone only gives jurisdiction to a state on the ocean surface and floor. It does not provide air and space rights, so these are not allowed. Then we have the important exclusive economic zone, which extends up to 200 nautical miles from the baseline, and within EEZ, a coastal state has sovereign rights for the purpose of exploring, exploiting, conserving, and managing natural resources on the seabed and the subsoil. And it also has rights to carry out activities like the production of energy from the water, currents, and wind. And unlike the territorial sea and the contiguous zone, EEZ only allows for the above mentioned resource rights. It does not give a coastal state the right to prohibit or limit freedom of navigation or overflight, subject to very limited exceptions. Then we come to the high seas, and high seas refer to the ocean surface and water column beyond the exclusive economic zone, and it is considered as the common heritage of all mankind and is beyond any national jurisdiction. States can conduct activities in these areas as long as they are for peaceful purposes such as transit, marine science, and undersea exploration. So now let us look at what kind of questions can be asked in prelims and mains. So in prelims, question can be asked on UN clause, which is the United Nations Conventions on Law of the Seas, or the International Tribunal on the Law of the Seas. Also, question can be asked on Permanent Court of Arbitration, which is at The Hague. Then a question can be on this particular incident and which ship was involved. So it was a commercial oil tanker having Italian flag named Enrica Lexi, and the case is of 2012. Then a question can be based on the location where this incident happened. So it happened off the coast of Kerala. In mains, question can be on UN clause, on Enrica Lexi case in particular, that what has been the verdict and what has India gained out of the verdict and where India has lost out. Also, a question can be on India-Italy bilateral relations. It can also be on India-European Union bilateral relations, and how does this case impact it. So this was all in today's editorial analysis. We'll see you next time with another editorial. Thank you.